the greenhouse gas and difference with scope. Now, we need to bear in mind, right, what the court said, right? When it comes to alteration of articles, right, the first thing that a company needs to satisfy, right, is the legitimacy test. In other words, did it follow the proper procedures? Now, 9 times out of 10, okay, almost all companies that alter their articles, yes, they would follow the proper procedures. So that's not difficult. The difficulty is, right, is how do you judge whether it is in the bona fide interest of the company as a whole? So the question is, like, what does company as a whole mean? Now, of course, when the court looks at a factual situation, right, it would have to balance the interests of different constituents of a company. So we have, on the one hand, right, we have the majority shareholders, and we have the minority shareholders. Now, what the court said was, right, the fact that your interests as a minority shareholders would be affected, that does not mean it is not in the interest of the company as a whole. Now, because on a commercial basis, okay, what the court said was, right, sometimes, okay, there might be reason why the controlling majority wants to control the company. For example, there might be a legitimate commercial purpose, okay, why they want to have full control of the company. For example, easier management, easier decision making, etc., etc. So the fact that your interest as a minority shareholder would be affected, okay, does not mean it is not in the interest of the company. Now, sometimes, right, for economic reasons, right, for example, the court says, right, sometimes it may be beneficial, okay, for the shares, for a company to bring in an outsider, okay, outside investment. That could be a legitimate commercial purpose. Yes, of course, the right of preemption, okay, of a minority shareholder would be affected, but it may be beneficial sometimes to bring in an outsider to the company, new investment, new ideas, new concepts. Now, but it doesn't mean, right? It doesn't mean whenever the articles are altered, okay, the majority shareholders simply have to say in the interest of the company. It doesn't work that way, okay? You must prove that it is, okay, the majority shareholder. You must prove that on balance, it is in the interest of the company as a whole. Because what the court says, right, that is just a legal test. Okay, that itself is just a legal test. Okay, but the outcome, okay, the outcome is a factual test. Now, but in other parts of the Commonwealth, okay, they look at this in a relatively different way. Now, this was illustrated in an Australian case called Gambottle versus WCP. Now, what happened in this case was the majority shareholder of WCP was a company called IEL. And they held 99.7% of WCP's shares. And the plaintiff, Mr. Gambottle, held about 0.09% of WCP's shares. Now, to cut a long story short, what happened was IEL wanted to acquire all of WCP shares, and they argued this was for tax and administrative purpose, okay, to save tax and administrative costs. So they approached Mr. Gambottle to purchase his shares, but Mr. Gambottle refused. IEL then decided to alter the constitution of the company to allow a shareholder with more than 90% shares forcibly acquiring a minority shareholder's shares. Okay? So they wanted to alter the Constitution. Insert a term in the Constitution whereby any shareholder holding more than 90% of the company shares can compulsorily acquire a minority shareholder's shares at a fair value. Now, given that they held more than 99% of company shares, right? It meant procedurally, right? Of course, they would pass the test. Okay, so it was legitimate. The special resolution by a 3/4 majority, right? All you needed was 75%, but they held 99.97%. So procedurally, yes, it was legitimate. Now, after amending the Constitution, they then proposed to buy the shares from Mr. Gambottle for $1.85 Australian a share, but Mr. Gambottle refused. So after amending the articles, they offered $1.85 Australian a share to Mr. Gambottle, but Mr. Gambottle refused. And the dispute ended in the court, and the issue before the court was whether the alteration to compulsorily acquire Mr. Gambottle shares was valid. Okay? Whether the alteration to compulsorily acquire Mr. Gambottle shares was valid. Okay, so 99.7% altering the articles of the company and compulsorily acquiring 0.09% of Mr. Gambottle shares. Was that valid? Was the alteration of the articles valid? Now, what the High Court of Australia here did was, right, they developed a test called the proper purpose test. Okay? They developed a test called the proper purpose test. Now, what they did in this case was, the High Court of Australia, they rejected the classical bona fide benefit test developed under Allen versus Goldreef. They developed the proper purpose test, and then rejected the classical bona fide benefit test developed under Allen versus Goldreef. Now, what they did in this case was, right, the majority of the High Court of Australia, they laid down a two-limb test, two-stage test, that must be satisfied when altering a constitution to permit expropriation. Number one, according to the High Court, right, the power is exercisable for a permissible purpose. Okay? The power must be exercisable for a permissible purpose. Number two, its exercise will not operate oppressively in relation to minority shareholders. The exercise will not operate oppressively in relation to minority shareholders. Okay? Permissible purpose, operate in a manner not oppressive to minority shareholders. Now, so who has to prove that it is for a proper purpose? The majority, okay? The party trying to amend the article. Okay, so the onus of proof, if you claim that it is for a proper purpose, then the onus of proof lies on you to prove that it is for a proper purpose. Okay, so it's a permissible purpose, operating in a manner not oppressive to minority shareholders. Okay, that's the two-stage test of the proper purpose test. Now, what about the present case then? Okay, so the question that the court has to answer is, right, number one, is it for proper purpose? And number two, okay, is it oppressive? Now, what the court said was, right, a company can only alter its constitution to force acquisition of shares when the acquisition is necessary to promote or to protect a legitimate purpose in the interest of the company as a whole, and at the same time, not oppressive to the minority shareholders. In other words, you have to pass both tests, okay? Not one or the other. Okay, you have to pass both tests, i.e. both stages of the test, not one or the other. Now, on the facts, what the court decided was, right, number one, was it for a proper purpose? They said yes, because what the company claimed was, the reason why they wanted to do that was for tax and administrative benefits. Is that for a proper purpose? Is that for commercial purpose? Yes. So that is a permissible purpose. But on the second part of the test, was it oppressive to minority shareholders? Yes. Okay? Was it oppressive to minority shareholders? Yes. Why? Because on the facts, okay, what the company didn't do was they did not disclose all the relevant information to Mr. Gambotto in exercising their right. So, is the expropriation lawful and reasonable? According to the court, no. Okay, so in other words, right, you have to pass both stages, okay? Permissible purpose, or permissible commercial purpose. Secondly, is it oppressive to minority shareholders? In other words, what the High Court of Australia is saying is that, right, a company simply cannot say it is for a commercial purpose, full stop. You have to show, right, number one, how is it beneficial to the company as a whole, right? The onus of proof lies on you claiming that it is for commercial purpose, or legitimate commercial purpose, so you have to prove that, number one. And secondly, on a factual basis, you also need to prove it is not oppressive to minority shareholders. Now, the outcome of this case was possible because, as I said, right, because the company here, right, REL, they control 99.7% shares. And Mr. Gambotto held about 0.09%, okay? Now, based on such imbalance, okay, probably the court held it was oppression. But if we just twist the facts around a bit, we're supposing Mr. Gambotto controlled 20% of the company shares. Or let's say 10% of the company shares, and REL control 90%. Now, would the outcome have been different? Now, because what the court have said was, right, the fact that you as minority shareholders' interests would be affected, okay, that does not mean it is not in the benefit of the company as a whole. Now, because what the court said was, right, as far as a business is concerned, sometimes gaining full control does have a commercial purpose, does have a legitimate commercial purpose. Now here, okay, what the majority share argued was, right, they were doing this for tax and administrative benefits. So the court said, yes, this is for commercial purpose, or legitimate commercial purpose. But the only reason why it was not fair on Mr. Gambottle, okay, was number one, he held only 0.09% of shares. And more importantly, what the court said was right, they did not disclose all the relevant information to Mr. Gambottle when they were trying to acquire his shares. Now, because the company, right, eventually offered 1.85 Australian shares. Now, what if the company offered $2.50 a share? Would that have been different? What if the company paid a premium? In other words, the fair value of the share plus, say, 20% or 30% more. Now, would that have been different? Now, then you might ask, has the High Court of Australia overruled Allen versus Gilchrist? Now, the answer to that question is probably no. Okay. Now, they did not fully say Allen versus Gilchrist doesn't apply. Okay. All it says was, right, we need to look beyond, okay, beyond the proper purpose. So in other words, legitimate commercial purpose, okay, is still the foundation for altering a rule or articles of an association. Okay, legitimate commercial purpose, i.e., or to put it simply, in the interest of the company as a whole, right? That is still a foundation for altering the company's article. But whether or not it is factually fair and reasonable, okay, is a matter of fact. Okay, any questions?
Since this is an Australian case, does it apply?
Can? Yeah, it can apply. Because under the basic law, we are allowed to refer to any judgment by company anywhere. UK, Australia, Canada, US. Yes, okay, so in other words, yes. So as I said, right, the foundation, okay, the foundation for altering an article, okay, it's still the legitimate commercial purpose test. So in other words, is it in the best interest of the company as a whole? That remains the foundation. But the outcome, okay, the factual outcome would depend on the fact based on the relevant cases. Now because what the High Court of Australia is saying is, right, yes, if you claim that it is for a proper commercial purpose, then it is for you to prove it based on the facts. So the burden of proof in proving that it is for a commercial purpose lies with the party that claimed it is for legitimate commercial purpose. But the foundation, okay, for altering the articles, okay, is still the same. Any other questions?